My medical device partner told industry colleagues first to file wins in the new patent system when he claimed sole invention of our collaborative cardiac monitoring device by filing identical patent applications under his personal company. My name is Christopher Hughes, 43 years old, biomedical engineer with 16 years of medical device development experience, specializing in cardiovascular monitoring systems and FDA regulatory compliance. I had co-developed our innovative cardiac monitoring device through systematic prototype development and comprehensive technical documentation that ensured both optimal patient safety and regulatory approval for commercial medical device deployment. When Dr. Alan Morrison boasted at the Medical Technology Innovation Conference about his breakthrough cardiac monitoring patent applications, I simply said, "Congratulations on successfully navigating the patent application process." What Morrison didn't realize was that my methodical approach to medical device development included automated design tracking systems and comprehensive prior art documentation that would expose his systematic theft of our collaborative innovations, while proving my fundamental contributions to every core algorithm and regulatory compliance strategy. The discovery occurred on a Thursday afternoon when I was reviewing industry news during a brief break from our FDA submission preparation work. A MedTech Daily article featured Morrison as the innovative inventor behind Cardiac Core Technologies' breakthrough monitoring device, describing technical specifications that were identical to our collaborative development work. Christopher, the current patent landscape favors rapid filing over extended development cycles, Morrison explained during our emergency conference call while reviewing printed patent application documents. Medical device patents require aggressive intellectual property protection that maximizes competitive positioning before regulatory approval completion. I reviewed the patent filing announcement while noting Morrison's comfortable familiarity with patent terminology and his detailed knowledge of application procedures that suggested extensive private preparation without partnership consultation. Alan, our partnership agreement established joint ownership of all intellectual property and collaborative patent filing procedures, I observed, while examining the technical specifications that described innovations I had specifically developed. How did you address patent office questions about our joint development and shared regulatory compliance work? Morrison gathered his documentation with visible confidence. Christopher, your focus on FDA regulatory compliance prevented understanding of patent strategy dynamics. Intellectual property protection requires streamlined filing procedures that optimize patent positioning for maximum commercial protection. The explanation contradicted our established partnership agreement and raised immediate concerns about intellectual property theft and patent fraud that could compromise both our device development and regulatory standing with the FDA. I understand the patent timeline considerations. What specific technical demonstrations did you provide to validate our device's cardiac monitoring capabilities? Morrison distributed additional patent materials while avoiding specific details about technical verification and algorithm demonstration procedures. Christopher, sophisticated patent examiners conduct comprehensive prior art searches that evaluate technical innovation and commercial potential rather than development collaboration details. The patent applications validate our device's breakthrough capabilities through rigorous patent office assessment. I thanked Morrison for managing intellectual property protection and requested detailed information about patent terms and technical ownership arrangements. Then I began systematic review of our development documentation and partnership agreement compliance. The comprehensive design tracking system I had implemented recorded every algorithm iteration, technical contribution, and regulatory milestone with timestamps, version control authentication, and intellectual property classification markers. What I discovered during the first evening of analysis was sufficient evidence to contact my intellectual property attorney, Maria Rodriguez, for immediate consultation about patent theft and partnership agreement violations. The development records showed that Morrison had systematically misrepresented our collaborative technical work as his individual creation, while claiming exclusive ownership of algorithms and innovations that I had primarily developed. Maria, I need urgent consultation about patent theft by my medical device partner, I explained during our confidential phone call. The documentation shows systematic misappropriation of our joint technical work filed with the Patent Office as his individual innovation. Maria had handled medical device intellectual property disputes throughout her career and immediately recognized the seriousness of systematic patent theft in medical technology environments where IP ownership directly impacts FDA approval and commercial licensing. Christopher, if Morrison filed joint intellectual property as his individual creation with the Patent Office, you're looking at patent fraud and potential federal IP violations, she explained. The evidence I was compiling showed not just partnership disputes, but systematic intellectual property theft designed to eliminate my co-inventor status while appropriating years of collaborative medical device development for individual commercial benefit. Morrison had apparently been studying patent law changes and medical device IP strategies while planning to systematically exclude me from patent protection and commercial licensing opportunities. Morrison's patent applications occurred during my focus on FDA submission work when he knew I would be unavailable to challenge his ownership claims, I documented. His systematic timing proves premeditated intellectual property theft rather than spontaneous patent optimization. The automated development systems revealed that Morrison had been systematically studying our technical architecture and regulatory documentation while preparing patent applications that would claim exclusive technical ownership. Morrison accessed our complete technical documentation and regulatory compliance history to create patent applications claiming individual ownership, I noted. His systematic appropriation of joint intellectual property constitutes comprehensive partnership fraud. The partnership agreement protections I had insisted upon during our medical device startup formation included specific safeguards against unilateral IP decisions and required joint authorization for patent applications exceeding our established collaboration thresholds. Our partnership contract explicitly requires joint authorization for patent applications and prohibits either partner from claiming exclusive ownership of collaborative technical work, I documented. Maria reviewed my preliminary evidence and immediately recommended comprehensive documentation preservation and potential patent office notification about Morrison's misrepresentation of intellectual property ownership and collaborative development. Christopher, the Patent Office conducts extensive prior art searches that include inventor verification, Maria advised. Morrison's misrepresentation creates both partnership violations and potential patent fraud liability. The FDA submission documentation I had filed established comprehensive prior art evidence that predated Morrison's patent applications by several months, creating irrefutable proof of collaborative development that contradicted his individual inventor claims. My FDA submission documents demonstrate joint intellectual property development that contradicts Morrison's claims of individual technical creation, I noted. The comprehensive regulatory documentation proves systematic collaboration rather than solo inventor innovation. Morrison's confidence about patent filing advantages was about to encounter systematic evidence and legal enforcement that would expose every aspect of his intellectual property theft. Have you ever discovered that someone exploited your regulatory compliance focus to steal collaborative medical innovations while claiming individual patent ownership? Medical device intellectual property requires comprehensive documentation when trusted partners attempt systematic appropriation of joint technical development. My 16-year career in biomedical engineering and medical device development had been built on the foundation of systematic innovation methodology and comprehensive regulatory compliance that transformed complex cardiovascular monitoring concepts into FDA-approved medical devices serving healthcare providers worldwide. The expertise I had developed in cardiac monitoring algorithms and regulatory strategy represented years of specialized research that had generated multiple FDA clearances and industry recognition for breakthrough medical technology innovations. I had established my biomedical engineering career in 2008 after completing my master's degree in biomedical engineering at Johns Hopkins University, where I specialized in cardiovascular monitoring systems with additional focus on FDA regulatory compliance and medical device commercialization strategies. Christopher's systematic approach to medical device development and regulatory compliance provides innovative solutions that exceed FDA safety standards while advancing cardiovascular patient care, noted early performance evaluation from Medtronic Cardiac Division Director, Dr. Sarah Martinez. The technical methodology I had developed emphasized comprehensive algorithm documentation, combined with rigorous regulatory compliance that ensured maximum patient safety while enabling commercial deployment opportunities with healthcare institutions seeking advanced cardiac monitoring capabilities. Hughes's medical device innovations generated breakthrough improvements in cardiac monitoring accuracy that established new industry benchmarks for patient safety and clinical effectiveness, documented Quarterly Research Review from 2015. The transition to independent medical device development in 2019 had reflected my recognition that cardiovascular monitoring innovations required specialized commercial focus and systematic partnership structures that could support both technical development and FDA regulatory approval requirements. Dr. Alan Morrison had approached me in 2020 when my cardiac monitoring research had attracted attention from medical device investors seeking to commercialize advanced cardiovascular technologies and FDA-approved monitoring systems. Alan's clinical background and medical device experience will complement your technical innovation capabilities, I had reasoned when establishing our partnership agreement for Hughes Morrison Medical Technologies. Morrison brought solid credentials in clinical medicine and claimed experience in medical device commercialization, though his attitudes towards systematic technical documentation and comprehensive intellectual property protection had gradually created tension within my methodical approach to device development. Christopher, your documentation requirements exceed standard medical device development practices, Morrison had complained regularly during quarterly technical reviews. Efficient device development requires rapid iteration cycles rather than excessive technical verification and patent preparation procedures. I had consistently explained that comprehensive documentation was essential for both FDA approval and intellectual property protection in the highly regulated medical device marketplace. Alan, FDA reviewers require detailed technical verification and systematic intellectual property documentation, I would respond during strategy discussions. Comprehensive documentation ensures regulatory approval while maximizing commercial licensing value through proven innovation claims. But Morrison viewed systematic documentation as obstacles to rapid device commercialization rather than essential protection for valuable intellectual property that required years of technical development and substantial regulatory investment. Excessive documentation prevents aggressive patent filing and competitive market positioning, Morrison had argued during business development planning sessions. The cardiac monitoring device that had precipitated Morrison's intellectual property theft represented our most significant technical innovation, including breakthrough algorithm development and regulatory compliance strategies that had attracted interest from major medical device companies. Our cardiac monitoring system provides innovative patient care solutions that enhance cardiovascular diagnosis while creating substantial commercial licensing opportunities, I had documented during technical strategy planning. The patent applications that Morrison had filed represented systematic appropriation of our collaborative technical work, including algorithms and regulatory strategies that I had developed through years of specialized cardiovascular monitoring research. Independent technical assessments consistently recognized my fundamental contributions to our device's core algorithms and regulatory compliance strategies, I had noted during partnership planning discussions. But Morrison had apparently been studying patent law requirements and medical device IP strategies while planning to circumvent our established intellectual property collaboration during my FDA submission focus. The regulatory compliance intensity that had enabled Morrison's IP theft represented critical FDA submission work that required concentrated focus on safety verification and clinical validation for medical device approval readiness. Advanced medical device development requires systematic regulatory focus that eliminates distractions from commercial development and patent strategy, I had explained during development planning discussions. The partnership agreement we had established included specific provisions for regulatory development periods and intellectual property protection that were designed to protect both partners' contributions while ensuring continued collaboration during intensive FDA submission phases. Our partnership structure accommodates regulatory development focus while requiring joint authorization for major IP decisions and patent applications I had established during initial legal consultations. The intellectual property restrictions I had insisted upon limited Morrison's authority to routine business operations while explicitly excluding patent applications, licensing negotiations, and IP distribution from unilateral decision-making. Partnership intellectual property provisions specifically exclude device patents and commercial licensing from individual decision authority, our agreement specified. Morrison had apparently been studying these IP protection provisions while planning to circumvent algorithm ownership documentation during my FDA submission periods when I was focused on regulatory compliance rather than patent oversight. Morrison's questions about intellectual property transfer procedures and patent application authority suggest preparation for unauthorized IP appropriation, I had noted in development documentation. The systematic technical documentation I maintained through automated development systems provided comprehensive evidence that would expose Morrison's unauthorized claims while protecting both patent applications and FDA regulatory submissions. The medical device development work that informed our cardiac monitoring system created technical complexities that Morrison had apparently underestimated when planning his unauthorized patent applications to patent office examiners lacking specific cardiovascular expertise. Cardiac monitoring algorithms require specialized biomedical knowledge that Morrison lacks, I observed. His unauthorized patent applications contained technical capability claims he couldn't demonstrate or verify through independent development. The medical device industry relationships I had built through technical conferences and regulatory publication were being systematically exploited by Morrison while he presented our collaborative innovations as his individual technical achievements. Industry recognition of my technical contributions contradicts Morrison's claims of solo inventor innovation, I documented. My published research and FDA submissions establish clear technical ownership that patent office examiners can independently verify. Morrison's exploitation of my FDA submission, focused to steal collaborative intellectual property, violated both partnership agreements and patent office disclosure requirements, while potentially compromising years of medical device innovation and regulatory compliance work. The comprehensive technical documentation I had maintained for patent protection and FDA verification would provide irrefutable evidence of collaborative development while exposing Morrison's systematic misrepresentation to patent office examiners and medical device regulatory officials. The cardiac monitoring expertise I had developed through FDA submission work was creating additional evidence that Morrison's patent claims were technically impossible without collaborative development and specialized cardiovascular knowledge that exceeded his individual capabilities. Morrison's patent applications claimed individual development of algorithms requiring collaborative biomedical expertise and FDA regulatory knowledge, I noted. His technical misrepresentations to patent office examiners create fraud liability beyond partnership violations. Have you ever realized that systematic medical device documentation becomes essential evidence when partners exploit regulatory compliance focus periods for intellectual property theft? Medical device collaboration requires comprehensive protection when trusted relationships become exploitative during intensive FDA submission work. The comprehensive investigation I conducted during my first month after discovering Morrison's patent applications revealed that his intellectual property theft wasn't opportunistic patent filing during my FDA focus, but a carefully planned scheme to systematically eliminate my co-inventor status while appropriating our collaborative medical device innovations for maximum personal patent protection and commercial licensing control. My forensic analysis of development systems and patent application records showed that Morrison had been systematically studying patent office procedures and medical device IP strategies while coordinating with patent attorneys to plan optimal timing for intellectual property appropriation during my predictable FDA submission periods. Morrison's patent application preparation activities began 4 months before his patent office filings. I documented while reviewing automated development logs and communication records. His systematic planning proves premeditated intellectual property theft rather than spontaneous patent optimization. The sophistication of Morrison's scheme included coordination with patent consultants who were advising him about patent office preferences for individual inventor narratives while helping him develop application materials that would obscure collaborative development and joint intellectual property ownership. Morrison coordinated with patent strategy associates to develop patent applications that systematically excluded evidence of collaborative development, I noted while examining consulting contracts and application materials. His systematic coordination with patent advisors enabled comprehensive intellectual property theft, but Morrison had made critical errors that would expose his systematic fraud and provide overwhelming evidence for both patent office investigation and partnership enforcement proceedings. The automated development tracking systems I had implemented included mandatory collaborative verification and intellectual property classification protocols that Morrison could not circumvent without creating obvious evidence of systematic documentation manipulation. Morrison's attempts to modify development attribution and intellectual property markers created comprehensive audit trails of unauthorized access I compiled while reviewing system security logs. The technical evidence proves systematic IP theft rather than legitimate individual inventor development. The intellectual property attorney Maria Rodriguez reviewed my expanded evidence compilation and immediately recognized the systematic nature of Morrison's patent theft and the potential for both civil recovery and patent office fraud investigation. Christopher, Morrison's activities show classic patterns of systematic medical device IP theft involving patent office misrepresentation and deliberate violation of partnership agreements, Rodriguez observed. The documented evidence proves intentional intellectual property appropriation and potential patent fraud. The technical methods Morrison had used to facilitate his IP theft included creating false development timelines and submitting fraudulent capability assessments that would justify individual inventor claims to patent office examiners, conducting technical verification. Morrison fabricated individual development narratives and submitted false technical capability documentation to support unauthorized sole inventor claims, I documented. His systematic falsification of development history constitutes fraud in addition to partnership violations. The Patent Office communication analysis revealed that Morrison had been systematically misrepresenting our collaborative technical work and partnership structure, while avoiding specific questions about co-inventor authorization and prior art verification. Morrison provided false representations to Patent Office examiners about exclusive technical ownership and individual development capability, I noted. His systematic examiner deception proves fraudulent intent rather than legitimate individual inventor positioning. Most concerning was Morrison's systematic access to my FDA submission documentation and technical research files that he had been exploiting to create believable patent applications, while claiming exclusive ownership of innovations I had primarily developed. Morrison accessed confidential FDA submission documents and research files to create patent applications, claiming individual technical ownership, I documented. His exploitation of privileged technical information enabled systematic intellectual property theft. The Patent Office prior art records revealed that Morrison had been providing false technical specifications and development timelines while misrepresenting the scope of his individual technical contributions versus collaborative development work. Morrison submitted false technical documentation and misrepresented algorithm development to facilitate patent applications, I noted. His systematic Patent Office fraud created additional liability beyond partnership violations. The timeline analysis revealed that Morrison's intellectual property theft had accelerated during my final FDA submission period when he realized that regulatory approval completion would provide optimal timing for patent application filing. Morrison's patent application timing coincided with completion of our FDA submission work, I calculated. His systematic exploitation of regulatory development timing proves premeditated IP theft rather than spontaneous patent opportunity. Rodriguez recommended immediate patent office notification and comprehensive evidence preservation to prevent Morrison from completing additional fraudulent patent applications or destroying incriminating documentation. Christopher, we need immediate patent office intervention to prevent Morrison from filing additional fraudulent patents while investigators examine the full scope of systematic IP theft, Rodriguez advised. Your comprehensive documentation provides overwhelming evidence for both patent fraud investigation and partnership enforcement. The United States Patent and Trademark Office fraud investigation procedures for medical device patents were designed to protect both inventors and the patent system from systematic misrepresentation of intellectual property ownership and technical development. Morrison's patent misrepresentation may violate federal patent fraud regulations governing medical device IP and inventor verification, Rodriguez explained. His systematic fraud creates both civil liability and potential criminal exposure. The evidence preservation process required securing all digital development records, FDA documentation, and patent communication logs before Morrison realized that his IP theft had been comprehensively documented through automated tracking systems. We need to preserve all evidence immediately while implementing patent office notification procedures, Rodriguez advised. Morrison cannot be allowed to destroy records or continue fraudulent patent applications. The FDA submission verification procedures that I had maintained throughout our medical device development provided irrefutable evidence of collaborative innovation that would expose Morrison's false individual inventor claims to patent office prior art searches. Your FDA submissions establish clear prior art evidence that predates Morrison's patent applications, Rodriguez observed. The comprehensive regulatory documentation eliminates any possibility of legitimate individual inventor claims. The Patent Office's prior art search standards included specific verification requirements for medical device innovations and technical capability claims that Morrison had systematically violated through fraudulent applications. Morrison's patent applications violated standard Patent Office prior art requirements for medical device verification and technical capability authentication, Rodriguez noted. His systematic misrepresentation creates comprehensive patent fraud liability. The automated development systems were providing real-time evidence of collaborative technical work that directly contradicted Morrison's individual inventor applications while establishing clear intellectual property ownership through systematic documentation. Your development tracking systems provide comprehensive evidence of collaborative innovation that makes Morrison's individual inventor claims impossible to defend, Rodriguez explained. The technical documentation eliminates all credibility for his patent applications. Morrison's confidence about patent filing advantages was about to encounter systematic evidence and patent office enforcement that would expose every aspect of his intellectual property theft while ensuring comprehensive partnership protection and inventor verification. The comprehensive IP protection I had implemented was transforming attempted patent theft into complete evidence for both patent office fraud investigation and partnership enforcement while establishing clear ownership of our collaborative medical device innovations. Have you ever discovered that systematic medical device documentation could expose patent theft designed to eliminate co-inventor status? Technical collaboration protection sometimes becomes essential for detecting sophisticated fraud schemes targeting patent office applications through misrepresented ownership claims. The strategic legal and patent office response that Rodriguez and the intellectual property enforcement system developed required careful coordination between patent fraud investigation, partnership agreement enforcement, and medical device regulatory protection to maximize IP recovery, while ensuring appropriate accountability for Morrison's systematic patent theft and federal intellectual property violations. Christopher, Morrison's unauthorized appropriation of joint medical device IP creates exposure under patent fraud statutes partnership protection laws, and medical device regulatory disclosure requirements, Rodriguez explained during our comprehensive strategy session. The evidence you've compiled supports simultaneous patent office investigation and partnership enforcement that will ensure complete IP recovery and maximum accountability. The Patent Office fraud investigation strategy focused on Morrison's violations of prior art disclosure requirements and unauthorized misrepresentation to patent examiners that warranted immediate federal intervention and comprehensive intellectual property protection. Your development documentation establishes clear prior art that predates Morrison's patent applications by months, Rodriguez noted. Morrison's systematic misrepresentation to patent office examiners constitutes federal patent fraud that justifies immediate enforcement action. But the most immediate priority was preventing Morrison from completing additional fraudulent patent applications while investigators built comprehensive cases for both intellectual property recovery and patent fraud prosecution. We need emergency patent office intervention to prevent Morrison from filing additional fraudulent patents while preserving evidence for comprehensive enforcement, Rodriguez recommended. The patent fraud notification documentation I was preparing included comprehensive evidence of Morrison's systematic IP theft, prior art violations, and federal patent fraud that warranted immediate patent office investigation and application rejection procedures. Morrison's activities constitute multiple violations, including patent fraud, prior art concealment, and systematic misrepresentation to federal patent examiners, Rodriguez explained. Meanwhile, I was coordinating with FDA regulatory specialists to ensure comprehensive medical device protection while building intellectual property enforcement cases and maintaining focus on continued device development and regulatory compliance advancement. Rodriguez, Morrison's IP theft is creating disruption during critical medical device development when our cardiac monitoring system requires focused regulatory advancement, I noted. The systematic patent violations are compromising both business operations and FDA regulatory progress. The technical analysis I was conducting revealed that Morrison's patent applications had not just misrepresented ownership, but had also made impossible technical capability claims that he couldn't demonstrate through legitimate development work or medical device expertise. Morrison claimed individual development of algorithms requiring collaborative biomedical expertise that he doesn't possess, I documented. His technical misrepresentations to patent office examiners create additional fraud liability beyond partnership violations. The forensic analysis that Rodriguez arranged showed that Morrison's patent applications contained technical specifications that were impossible to develop without collaborative medical device expertise and FDA regulatory knowledge that exceeded his individual capabilities. Morrison's patent applications claimed individual technical achievements that required collaborative development and specialized medical device knowledge, forensic analyst Lisa Chen calculated. The technical analysis proves systematic misrepresentation rather than legitimate individual inventor capability. The United States Patent and Trademark Office investigation that began within 72 hours of our notification included comprehensive examination of Morrison's patent applications and prior art verification by experienced medical device patent fraud specialists. Morrison's patent applications appear to violate fundamental Patent Office prior art requirements, lead patent examiner Michael Torres reported after reviewing preliminary evidence. The Patent Office investigation was revealing that Morrison's medical device patents violated multiple intellectual property regulations, including prior art disclosure, inventor verification, and technical capability authentication requirements. Morrison's systematic misrepresentation violates Patent Office disclosure standards and medical device patent verification requirements, Examiner Torres noted. But Morrison's most serious error was systematically falsifying technical development documentation and prior art disclosure while coordinating with patent consultants to create fraudulent application materials that violated federal patent fraud statutes. Morrison created false technical documentation and coordinated with patent consultants to facilitate systematic patent office fraud. Rodriguez observed. His coordinated misrepresentation creates enhanced federal patent fraud liability. The Federal Bureau of Investigation Intellectual Property Division was triggered when Patent Office investigators discovered that Morrison's fraud potentially affected multiple patent applications and federal IP protection regulations governing medical device innovations. Morrison's systematic misrepresentation may violate federal IP protection laws governing medical device patents and inventor verification requirements, FBI investigator Jennifer Walsh explained. The Department of Health and Human Services investigation was examining whether Morrison's patent fraud represented broader threats to medical device innovation and FDA regulatory compliance that depended on accurate intellectual property disclosure. Morrison's systematic patent fraud threatens medical device innovation and regulatory compliance systems, HHS investigator Sarah Davis reported. The comprehensive evidence compilation was supporting both civil partnership enforcement and potential federal patent fraud charges that could result in substantial financial penalties, plus complete restitution of appropriated intellectual property and patent damages. Morrison's documented activities support civil enforcement and potential criminal charges that carry combined penalties exceeding $500,000, patent fraud prosecutor Robert Wilson explained. The international implications were also significant, as Morrison's IP theft could affect medical device patent applications and licensing agreements that involved multinational healthcare partnerships and device development collaborations. Morrison's stolen medical device algorithms support international patent applications and licensing agreements with European and Asian healthcare companies, patent licensing analyst Patricia Newman noted. His unauthorized appropriation creates international intellectual property complications. The Patent Office examiner's recognition of systematic prior art violations was creating immediate pressure for application rejection and comprehensive intellectual property restoration, while exposing Morrison's misrepresentation to medical device industry oversight. Patent Examiner Review has identified systematic prior art violations that invalidate Morrison's applications, Patent Office counsel reported to enforcement investigators. The intellectual property recovery process was identifying additional medical device innovations that Morrison had attempted to appropriate without authorization, including proprietary development methodologies and FDA regulatory strategies. Morrison's fraud scheme included proprietary development software and regulatory compliance techniques that exceed core device algorithms, I documented. But the most significant development was the medical device community's recognition that my systematic documentation had prevented potential compromise of innovative cardiac monitoring technologies while enabling comprehensive patent office protection during federal patent fraud investigation. Hughes's medical device documentation prevented major innovation loss while providing comprehensive evidence for patent office protection, Medical Device Innovation Alliance Chairman Dr. Patricia Rodriguez noted. The coordinated patent office response was ensuring that Morrison's IP theft would result in both complete intellectual property recovery and maximum accountability, while protecting medical device innovation, integrity, and patent system security. Multiple agency coordination ensures comprehensive IP recovery, while preventing additional patent fraud targeting medical device innovation, Rodriguez observed. Morrison's systematic exploitation of my FDA submission focus was about to encounter coordinated federal enforcement that would expose the full scope of his crimes while ensuring appropriate protection for both personal intellectual property rights and medical device innovation security. The evidence I had compiled through automated development systems was enabling patent office teams to build comprehensive cases that addressed both individual fraud and broader threats to medical device intellectual property protection and patent system integrity. Have you ever required coordination between patent office investigation and partnership enforcement to address systematic intellectual property theft affecting medical device innovations? Sometimes comprehensive technical documentation becomes essential for protecting both individual inventors and broader innovation ecosystem integrity during patent fraud enforcement. The Coordinated Patent Office investigation that began executing 5 weeks after my initial fraud notification created immediate pressure on both Morrison and his patent consulting network, while exposing the systematic nature of his intellectual property theft to patent examiners, medical device investigators, and IP enforcement officials who had been unaware of his coordinated scheme to appropriate collaborative medical device innovations. The emergency patent application suspension that the United States Patent and Trademark Office implemented after reviewing my comprehensive evidence immediately prevented Morrison from securing patent protection while triggering automatic prior art verification procedures for all pending applications. Dr. Morrison's patent applications are subject to immediate suspension pending resolution of systematic prior art violations and inventor verification fraud, USPTO Director, Dr. Sarah Wilson announced. His documented IP misrepresentation creates immediate patent system violations that require comprehensive federal investigation. Morrison's response to the patent suspension orders revealed his growing panic as he realized that his intellectual property theft had triggered multiple patent office investigations and potential federal prosecution rather than the successful patent portfolio development he had anticipated. Morrison's emergency legal motions show desperation about suspended patent applications and recognition that his IP theft constitutes federal patent fraud, Rodriguez observed. His legal strategy indicates understanding that criminal prosecution is likely. The patent fraud charges that federal prosecutors filed included systematic prior art concealment, inventor verification fraud, and conspiracy to defraud the patent office that carried potential sentences exceeding 15 years in federal prison. Dr. Morrison faces federal charges including patent fraud, prior art concealment, and systematic misrepresentation to patent office examiners, Federal Prosecutor Wilson announced. His systematic IP fraud constitutes serious federal crimes that threaten patent system integrity and medical device innovation. The Patent Strategy Associates investigation was revealing that Morrison's IP theft had been coordinated with patent consultants who specialized in helping clients appropriate collaborative intellectual property through systematic prior art concealment and inventor verification fraud. Morrison coordinated with patent consultants who systematically advise clients about collaborative IP appropriation through patent office misrepresentation, Patent Office investigator Torres noted. His activities constitute coordinated patent fraud that threatens IP system integrity. But the most damaging development for Morrison was the medical device technical review that revealed his patent applications contained impossible technical claims that he couldn't demonstrate through legitimate development work or biomedical expertise. Morrison's patent applications claimed individual development of cardiac monitoring algorithms requiring collaborative biomedical expertise and FDA regulatory knowledge he doesn't possess, medical device technical reviewer Jennifer Adams reported. His technical misrepresentations created systematic patent office fraud beyond partnership violations. The FDA regulatory investigation was expanding to examine whether Morrison's patent fraud had compromised medical device regulatory compliance and innovation development that supported cardiovascular patient care and clinical effectiveness. Morrison's patent fraud may have affected FDA regulatory compliance for medical devices that serve cardiovascular patients, FDA investigator Robert Kim noted. His IP theft threatens medical device innovation and patient care systems. The medical device industry investigation was revealing that Morrison's fraud represented broader threats to biomedical innovation and intellectual property protection that depended on accurate inventor verification and collaborative development disclosure. Morrison's systematic patent fraud threatens medical device innovation and collaborative development systems, Medical Device Manufacturers Association investigator Davis reported. His activities compromise essential biomedical innovation and IP protection systems. The asset recovery process was proceeding rapidly as federal investigators traced patent consulting payments and fraudulent application development costs while implementing comprehensive restitution procedures for all affected intellectual property and development damages. Fraudulent patent consulting payments have been located and secured through multiple business accounts. Asset recovery specialist Linda Thompson reported. Morrison's fraud proceeds were unsuccessful in avoiding legal recovery due to comprehensive tracking capabilities. The plea negotiations that Morrison's patent attorneys initiated revealed their recognition that the comprehensive evidence made federal conviction inevitable, while intellectual property recovery was proceeding under Patent Office enforcement procedures. Morrison's legal team is requesting plea negotiations due to overwhelming evidence of systematic patent fraud, Federal Prosecutor Wilson reported. His federal exposure eliminates most defense strategies, but Morrison's emotional breakdown during federal depositions revealed the psychological pressure of facing multiple patent fraud charges and recognition that his IP theft scheme would result in substantial federal penalties and permanent exclusion from patent system participation. Morrison broke down completely when Patent Office investigators presented evidence of his systematic IP theft and prior art concealment, patent investigator Torres reported. His confession included admission of fraudulent intent and patent consultant coordination. The confession provided federal investigators with detailed information about Morrison's patent theft methods and consultant coordination, while identifying additional medical device innovations that had been systematically targeted for collaborative IP appropriation. Morrison's cooperation revealed systematic patent fraud affecting multiple medical device partnerships and collaborative innovation projects, Prosecutor Wilson noted. His confession provides evidence for protecting additional medical device inventors from similar fraud schemes. The Patent Strategy Associates coordination investigation was expanding as federal teams discovered that the consulting firm had been systematically advising clients about collaborative IP elimination strategies and individual inventor positioning through prior art concealment. Patent Strategy Associates coordination with Morrison suggests systematic patent fraud services targeting collaborative medical device partnerships, federal investigator noted. The intellectual property restoration process was proceeding comprehensively as Patent Office enforcement implemented complete technical ownership recovery, plus enhanced damages for systematic partnership violations and patent fraud. Complete intellectual property restoration plus enhanced damages total $200,000 in comprehensive recovery, I calculated, while managing medical device development and legal coordination simultaneously. The Patent Office remedies address both individual harm and systematic patent fraud. The professional reputation recovery was exceeding expectations as biomedical colleagues and medical device contacts appreciated my systematic approach to exposing patent fraud while protecting collaborative medical device innovation and FDA regulatory compliance. Christopher's documentation and Patent Office reporting demonstrates exactly the kind of professional integrity needed for medical device innovation and biomedical collaboration, noted testimonial from Johns Hopkins biomedical engineering colleague Dorothy Martinez. The Medical Device Innovation Assessment was revealing that Morrison's patent fraud had threatened not just individual intellectual property, but also broader cardiovascular monitoring development programs that depended on collaborative innovation and systematic technical documentation. Morrison's patent fraud compromised cardiac monitoring development programs that could have generated breakthrough patient care innovations, medical device development researcher Patricia Newman observed. The United States Patent and Trademark Office was using our patent fraud documentation as model evidence for detecting and preventing systematic IP theft during collaborative medical device development and inventor verification procedures. Hughes's systematic documentation and Patent Office reporting provide excellent examples of protecting collaborative medical device innovation from patent fraud, USPTO Training Director David Martinez noted. The speaking opportunities at medical device conferences and intellectual property protection seminars were generating additional recognition while establishing my reputation as an expert in patent fraud detection and collaborative innovation protection during biomedical development. Hughes's experience demonstrates how systematic documentation and patent office reporting can expose and prevent medical device patent fraud, observed conference organizer Dr. Jennifer Walsh. Morrison's systematic intellectual property theft was about to result in comprehensive federal accountability, while validating systematic technical documentation and collaborative innovation protections as essential safeguards for medical device intellectual property and patent system integrity. The coordinated patent office response had transformed attempted IP theft into enhanced professional recognition while demonstrating the effectiveness of systematic documentation and federal oversight during patent fraud investigations targeting collaborative medical device innovation. Have you ever seen systematic patent fraud completely defeated through coordinated patent office enforcement that protected both individual inventors and broader medical device innovation integrity? Sometimes comprehensive documentation and federal reporting create industry-wide protection while ensuring appropriate criminal accountability for IP fraud violations during collaborative biomedical development. The comprehensive resolution of Morrison's patent fraud case occurred within 9 months of my initial patent office notification, delivering complete intellectual property recovery, enhanced professional reputation, and federal criminal accountability that exceeded initial expectations while establishing new medical device industry standards for protecting collaborative innovation from systematic patent theft. Morrison's settlement agreement on all federal charges included systematic patent fraud, prior art concealment, inventor verification fraud, and patent consultant coordination that resulted in $200,000 in damages plus permanent prohibition from patent system participation and complete restoration of my intellectual property ownership and co-inventor status. Dr. Morrison's systematic patent fraud represents a serious violation of collaborative innovation trust and patent office integrity, Federal Patent Judge Patricia Stevens stated during proceedings. His coordination with patent consultants to eliminate co-inventor status warrants substantial financial accountability and comprehensive IP restoration. The civil settlement required Morrison to transfer all medical device assets, including patent applications, technical documentation, and development materials that had been created using appropriated intellectual property and fraudulent inventor claims. Morrison's asset transfer ensures complete victim recovery, plus enhanced penalties that reflect the medical device innovation implications of his patent fraud, asset recovery specialist Thompson reported. The comprehensive restoration exceeds original theft amounts due to federal patent fraud penalties and collaborative innovation violation enhancements. But beyond financial recovery, Morrison's case created medical device industry recognition of systematic technical documentation as essential protection against intellectual property theft and collaborative innovation exploitation during FDA regulatory development periods. Hughes's comprehensive medical device documentation provided the evidentiary foundation for the most successful patent fraud resolution in patent office history, Medical Device Innovation Alliance Director Dr. David Martinez noted. His systematic approach should be adopted by all biomedical engineers facing partnership vulnerabilities and collaborative innovation risks. The professional opportunities that resulted from my ethical handling of Morrison's fraud exceeded anything our original partnership could have provided for medical device development and biomedical industry recognition. Hughes Cardiac Technologies, the independent medical device company I established using IP recovery proceeds and enhanced industry reputation, was attracting FDA regulatory officials and healthcare investors who valued proven biomedical integrity and comprehensive collaborative innovation documentation. Christopher's exposure of systematic patent fraud demonstrates exactly the kind of biomedical integrity we need for cardiac monitoring device development, noted investor testimonial from Johnson & Johnson Innovation Director Jennifer Adams. The medical device startup was receiving FDA expedited review consideration while providing professional satisfaction that focused on advanced cardiovascular innovation rather than patent fraud prevention and intellectual property protection. Independent medical device development with comprehensive IP documentation allows complete focus on biomedical innovation, excellence, and patient care advancement, I reflected during industry presentations. The former biomedical colleagues who joined Hughes Cardiac Technologies as senior developers represented validation that my algorithm expertise and ethical standards created more value than Morrison's fraudulent patent appropriation schemes. Christopher's systematic approach to medical device development and ethical partnership practices provide reliability and innovation capabilities that justify premium biomedical investment and FDA regulatory support, explained personnel metrics showing recruitment of 3 senior cardiovascular engineers. The speaking opportunities at medical device conferences and intellectual property protection seminars were generating additional revenue while establishing my reputation as an expert in patent fraud detection and collaborative innovation protection during biomedical development. Hughes's experience demonstrates how comprehensive technical documentation can expose and prevent systematic medical device patent fraud, observed conference organizer Dr. Jennifer Walsh. The Food and Drug Administration had implemented enhanced collaborative innovation protection recommendations based on Morrison's fraud case, creating new regulatory standards for preventing systematic patent theft during medical device development and FDA submission periods. Hughes's IP protection protocols have become model practices for medical device companies seeking to prevent patent fraud while maintaining comprehensive biomedical collaboration, FDA Innovation Protection Committee Director Lisa Chen noted. Morrison's complete professional destruction served as medical device industry warning about the consequences of systematic patent fraud and the importance of ethical collaborative practices during biomedical innovation and regulatory development. The Morrison case sends clear messages throughout the medical device community about federal enforcement capabilities for patent fraud and collaborative innovation violations, legal analyst Patricia Newman observed. But the most meaningful outcome was validation of systematic technical documentation and collaborative innovation protection as reliable safeguards against intellectual property theft during intensive FDA regulatory development and medical device approval processes. Morrison's case proves that comprehensive technical documentation and ethical biomedical collaboration create sustainable competitive advantages, I observed during ethics workshops. The medical device industry recognition I received for patent fraud prevention expertise had generated regulatory relationships and strategic partnerships that exceeded the financial benefits of traditional partnership arrangements. Hughes's ethical handling of patent fraud demonstrates biomedical integrity that attracts both FDA regulatory support and medical device industry collaboration opportunities, medical device consultant Sarah Davis noted. The enhanced FDA recognition I had achieved through ethical reporting was providing access to expedited regulatory review opportunities and approval pathways that reflected superior biomedical capabilities and verified collaborative integrity. Hughes Cardiac Technologies' proven patent protection and comprehensive biomedical innovation provide medical device capabilities that exceed traditional development approaches, regulatory testimonials showed. The comprehensive legal victory had demonstrated that systematic documentation and patent office protections provided more reliable intellectual property security than partnership relationships based on convenience rather than verified ethical standards and collaborative safeguards. Professional competence in patent protection creates biomedical security that transcends individual partnership arrangements, I noted during medical device leadership seminars. Morrison's systematic patent fraud during our medical device development had inadvertently created opportunities for enhanced biomedical independence, industry recognition, and meaningful cardiovascular innovation that exceeded anything our original partnership could have achieved. Sometimes the most systematic partnership betrayal creates catalysts for independent success and enhanced protection standards, I reflected during professional development workshops. The technical documentation methods that had exposed Morrison's fraud were being adopted by medical device partnerships while generating ongoing consultation revenue and industry leadership recognition. Hughes's patent protection protocols provide comprehensive security against collaborative fraud, while supporting legitimate medical device innovation, noted licensing agreement with Medical Device Partnership Protection Alliance. Morrison's attempt to steal collaborative biomedical innovations while exploiting my FDA regulatory focus had ultimately created opportunities for enhanced medical device independence, industry leadership recognition, and meaningful cardiovascular development that exceeded anything traditional partnership arrangements could have provided. The systematic approach to intellectual property protection that had defeated coordinated patent fraud was providing sustainable competitive advantages that attracted the most sophisticated medical device investors and FDA regulatory officials available to biomedical innovators with proven collaborative integrity. Have you ever discovered that systematic medical device documentation could transform attempted patent fraud into opportunities for enhanced biomedical success and industry recognition? Sometimes comprehensive IP protection becomes the foundation for independent success that exceeds traditional partnership benefits while advancing cardiovascular patient care innovation. Standing in the FDA-certified development laboratory of Hughes Cardiac Technologies, 18 months after Morrison's settlement and patent fraud conviction, I reflected on how his systematic theft of our collaborative intellectual property had inadvertently transformed my career from partnership management to industry leadership in cardiovascular monitoring innovation and medical device intellectual property protection. The independent medical device company had grown to secure FDA expedited review status while serving healthcare providers who valued proven biomedical integrity and comprehensive collaborative innovation above traditional medical device development approaches. The 6,800 square foot FDA-compliant facility accommodated advanced cardiac monitoring development capabilities and comprehensive intellectual property protection resources that supported both routine medical device consulting and specialized patent fraud prevention services that had become my professional specialty through patent office recognition and enhanced biomedical credentials. Working with a biomedical engineer who has personally tested comprehensive patent protection provides confidence and innovation security that eliminates concerns about intellectual property theft and collaborative exploitation, noted senior cardiovascular engineer Patricia Lynch, a former Medtronic specialist who had joined our team. The medical device company I had established was generating substantially higher FDA regulatory interest and clinical validation than my original partnership arrangement, while providing professional satisfaction that focused on advanced cardiovascular innovation rather than fraud prevention and patent protection management. Hughes Cardiac Technologies' systematic approach to biomedical innovation and ethical partnership practices provides medical device development that exceeds traditional collaboration standards. FDA Cardiovascular Device Director testimonial from Michael Torres noted, "The business expansion that had resulted from Morrison's prosecution, combined with patent office recognition for IP theft prevention expertise, had created professional opportunities that exceeded anything achievable through traditional medical device partnerships with shared intellectual property vulnerabilities." Christopher's transformation from fraud victim to industry patent protection leader demonstrates how systematic integrity and comprehensive documentation create lasting competitive advantages in medical device development, Medical Device Technology Review observed. But the most significant achievement was federal recognition that established me as the definitive expert in medical device patent protection and systematic technical documentation for biomedical engineers facing partnership vulnerabilities and collaborative innovation risks during FDA regulatory development. Hughes's experience provides unique insights into preventing and detecting patent fraud that threatens both individual biomedical innovation and broader medical device ecosystem integrity, Cardiovascular Innovation Review noted. The Food and Drug Administration had requested my participation in developing enhanced medical device IP protection standards and collaborative innovation protocols that would protect biomedical engineers from systematic patent theft and regulatory development exploitation. Hughes's technical documentation methods and fraud detection expertise provide essential guidance for strengthening medical device IP protection throughout the biomedical industry, FDA Innovation Security Committee Chair Dr. David Martinez explained. Annual speaking engagements at medical device conferences, patent protection seminars, and cardiovascular innovation workshops were generating supplemental income of $145,000 while reinforcing my expertise in systematic documentation and ethical biomedical partnership management. Hughes' systematic approach to patent protection and collaborative fraud prevention has become the industry standard for medical device companies working with cardiovascular monitoring innovations, American Medical Device Association President Jennifer Adams observed. Morrison's permanent patent system exclusion had concluded with complete intellectual property forfeiture, industry-wide recognition of his fraudulent practices, and ongoing legal restrictions that would prevent him from claiming ownership of collaborative biomedical work throughout his career. Morrison's systematic patent fraud resulted in the most comprehensive medical device IP theft resolution in patent office court history, Federal Prosecutor Wilson noted. His case demonstrates that patent fraud and collaborative exploitation carry severe professional consequences that cannot be avoided through sophisticated patent consulting coordination or patent office application manipulation. But Morrison's case had also created enhanced protection for medical device industry integrity by establishing legal precedents that strengthened patent enforcement and collaborative innovation protection capabilities during FDA regulatory development periods. The Morrison case clarified federal enforcement capabilities for systematic patent fraud and established deterrent effects throughout the medical device partnership community, legal analyst Robert Kim observed. The biomedical documentation methodologies I had developed and refined through Morrison's fraud exposure were generating licensing revenue from medical device partnerships who needed proven protection frameworks while ensuring proper patent office implementation and ethical oversight. Hughes' patent protection protocols provide comprehensive security against collaborative fraud, while supporting legitimate medical device innovation and optimal patient care outcomes, noted licensing agreement with International Medical Device Partnership Network. The professional reputation I had built through ethical crisis management was attracting strategic consultation opportunities with major medical device organizations who valued demonstrated integrity and systematic intellectual property protection expertise. Hughes Cardiac Technologies' proven patent integrity and comprehensive collaboration protection capabilities make them ideal consultants for the most sensitive medical device initiatives and cardiovascular innovation programs, explained consulting agreement with Medical Device Industry Consortium. Looking back on Morrison's systematic betrayal and attempted theft of our collaborative cardiovascular innovations, I realized that his sophisticated patent fraud had inadvertently created opportunities for professional growth, FDA recognition, and medical device success that exceeded anything traditional partnership arrangements could have provided. Sometimes the most comprehensive patent fraud becomes the catalyst for professional development and FDA recognition that transforms entire career trajectories into medical device industry leadership, I observed during biomedical excellence conferences. The systematic technical documentation that had exposed Morrison's fraud was serving as the foundation for expanded consultation services that helped other biomedical engineers prevent patent theft while maintaining ethical collaboration standards and comprehensive cardiovascular innovation protection. Morrison's theft attempt validated the commercial value of systematic patent protection while creating legal precedents that enhanced medical device industry-wide innovation security capabilities, I noted during professional development workshops. The comprehensive legal victory had demonstrated that systematic documentation and patent office protections provided more reliable biomedical security than partnership relationships based on convenience rather than verified ethical standards and intellectual property safeguards. Professional competence in systematic patent protection and ethical medical device development creates sustainable competitive advantages that transcend individual partnership arrangements or regulatory development strategies, I explained during FDA protection presentations. Morrison's attempt to steal collaborative cardiovascular innovations while exploiting my FDA regulatory focus had ultimately strengthened my professional position while creating consultation opportunities and patent office recognition that established Hughes Cardiac Technologies as the nation's leading advocate for ethical medical device development and comprehensive patent protection. The people who attempt to exploit FDA regulatory development through systematic patent theft sometimes end up creating opportunities for their victims to achieve greater success through validated expertise and comprehensive patent office recognition. I reflected during medical device industry leadership seminars. The experience had proven that professional competence in systematic documentation and ethical biomedical collaboration could transform attempted patent fraud into enhanced medical device success and federal authority that exceeded original partnership compensation arrangements. Morrison's systematic patent fraud had inadvertently provided the foundation for building patent office recognition, professional leadership, and medical device expansion that represented the most successful and meaningful period in my 16-year biomedical engineering career. Professional relationships built on systematic integrity and verified protection standards prove more durable and valuable than partnerships based on convenient arrangements or patent strategies that can be compromised through fraudulent activities and intellectual property violations. The medical device company that had emerged from systematic patent theft attempts was generating higher FDA interest, enhanced patent office recognition, and more meaningful cardiovascular relationships than anything traditional partnership arrangements could have achieved. Have you discovered that systematic medical device documentation and ethical biomedical practices can transform attempted patent fraud into opportunities for professional growth and patent office recognition? Sometimes, the most sophisticated intellectual property fraud becomes the foundation for building enhanced competitive advantages through validated expertise and comprehensive medical device industry authority. If this story of systematic documentation and medical device patent protection resonated with you, please hit that subscribe button to Revenge Tales with Luke. Share your experiences with patent fraud and intellectual property theft in the comments below. Your story might help someone else who's facing similar challenges with systematic IP appropriation and biomedical collaboration exploitation during FDA regulatory development. See you in our next story.